Have you ever pondered on the question, do laws exist to serve society, or does society exist to serve the laws? This question, at its core, reflects the contrasting philosophies of formalism and pragmatism in law. On one side of the spectrum, we have formalism, a school of thought that insists on the strict application of legal rules and principles. Formalism is like a stern judge, faithfully interpreting the letter of the law without bending to the complexities of the outside world. The emphasis here is on rules with a strict adherence to the literal interpretation of statutes and previous legal precedents. The goal, legal certainty and predictability. Then we have pragmatism, the flexible counterpart to formalism. Pragmatism is like a seasoned diplomat, navigating the often convoluted waters of real-world situations to achieve just and effective results. The focus here shifts from rules to consequences, with a flexible approach that considers the broader impact of legal decisions on society. As you can imagine, these contrasting philosophies often lock horns in the legal arena. Formalism, with its unwavering commitment to the written law, provides a sense of stability and predictability. However, its critics argue that this rigidity can sometimes lead to unfair outcomes, as it may not fully account for the complexities of real-world situations. On the other hand, pragmatism, with its emphasis on real-world context and flexibility, is often hailed for its ability to adapt to changing circumstances. However, this flexibility can sometimes lead to inconsistencies, and its critics argue that this could undermine the predictability of the legal system. The philosophical tug-of-war between formalism and pragmatism is a dance as old as law itself. The key, as with many things in life, lies in finding the right balance. A legal system that is too rigid may become inflexible and unjust, while a system that is too flexible may become unpredictable and inconsistent. Key figures in the development of pragmatism, a philosophical theory highlighting the tangible outcomes of ideas and the vital role of experience in forming beliefs, were William James and John Dewey. Let's delve into their significant contributions. William James. 1. Introduction of the pragmatic method. James introduced the pragmatic method to the world, promoting the practical impact of beliefs as their truth-defining criteria. He put forward the idea that the value of an idea in its consequences and its ability to guide action effectively. 2. Advocacy for pluralism. James was not a supporter of absolutism. Instead, his philosophy resonated with pluralism, the belief that truth is not uniform, but differs according to context. This logic aligns with the inherent flexibility of pragmatism. 3. Radical empiricism theory. James's philosophical thought also comprised radical empiricism, proposing experience as the bedrock of knowledge. This viewpoint enhanced pragmatism's focus on the practical outcomes of ideas rooted in real-life experience. John Dewey. 1. Instrumentalist perspective. Dewey broadened scope of pragmatism through his instrumentalist perspective. He proposed that ideas should be seen as tools to solve problems, thereby underlining the practical and problem-solving aspects of beliefs. 2. Experiential learning approach. Based on pragmatism, Dewey's educational philosophy underscored the significance of experiential learning. He was an advocate for education that was relevant to the individual and societal needs. 3. Social and political philosophy. Dewey applied pragmatism to social and political concerns, pushing for democracy and social reform. He was a firm believer in the adaptability of institutions to meet the evolving needs of a democratic society. James and Dewey made considerable contributions to the field of pragmatism by molding its essential principles and extending its reach beyond philosophical discourse to areas like education, psychology, and politics. Their focus on the practical outcomes of ideas and the crucial role of experience continues to influence various thinking fields. In conclusion, while formalism and pragmatism represent contrasting approaches to legal interpretation and decision-making, they both play crucial roles in shaping our legal landscape. Formalism provides the stability and predictability that society needs, while pragmatism ensures that our legal system remains adaptable and responsive to the ever-changing complexities of the real world. The challenge, as always, lies in striking the right balance.